Right, I have 2 court dates now coming up. I was able to push up my court date here in, I forget the name of the county again. Okamani, well, and it was September, but now I have it pushed to July 17th at 10:30 a.m. and I have to go to the courthouse. So, I mean, I'm happy for that. I wish it was kind of sooner, but I'll take the time to prepare because there's a lot to do still to prepare for this. I also have a court date on July 16th at 4 p.m. for the West Milwaukee case. So that's going to be a little stressful. I'm stressed just thinking about it. On July 16th, I have a hearing at 4 p.m. Then the next day at 10:30, I have another hearing. 2 separate crimes, 2 separate judges, just all condensed within 2 days. And I want to prepare for that. I don't want to confuse one over the other, but for both, we're still in the discovery phase anyway. So it's just like, on the 16th I ask for discovery, on the 17th I ask for discovery. They're aligned more. And this is the benefit. This is just a weird thing that's occurred for me. Never happened in my life. I was able to bump up the court date, the court hearing for Ogan Nomi County, but I was not able to bump up the hearing date for West Milwaukee. They just wanted to stick with the date. So it's on Zoom. I don't have to rush back to Milwaukee. If there was no Zoom for Milwaukee, I would be in trouble with that, I think. So I'm learning more about this forfeiture law from this most recent case, which I didn't know too much about out of West Milwaukee. I was just going to wait to talk to the judge and see what they have to say, but I'm learning more just getting into this, because once again I'm facing forfeiture law. No jail times associated with it. And they're saying forfeiture law. Well, I'm like, okay, what's the difference? And there's civil code, there's criminal code, and then apparently forfeiture law is like right in between. It can go back and forth. That's what ChatGPT said. I wonder if I can bring that up. Nah. Unfair aspects of forfeiture. Oh, I do have it. I'm offline, but ChatGPT has it still. There's let's see. Okay, I want to go to the top maybe. Oh geez, I got a lot going on here. Okay. Is there anything that looks fair it looks unfair in forfeiture law? So they're saying that I posted what I thought was relevant out of forfeiture law. Like, I deleted stuff like that said if you didn't show up, they'll put a warrant out for your arrest. So I deleted a bunch of the forfeiture law. It's all under 778. Okay, And then what I thought was relevant, because ChatGPT, I didn't know if they had enough room to take all of the forfeiture law. Okay. Yeah, okay, here we go. Here's the answer. Here are some potential issues that might be seen as unfair in the Wisconsin forfeiture law. You will get imprisoned for unpaid judgments. So, if a judgment for a forfeiture is not paid, the defendant can be imprisoned for up to 6 months. So, I mean, why shouldn't we get a free lawyer if, they may say, this first step, if the judge finds you guilty, you just only have to pay money. But if you don't pay that money, then you could face 6 months in jail. So, I mean, they've put a wall in between, they put a barrier in between your right to a lawyer or not. And I'm guessing that maybe that second phase of the collections, when they have a warrant for your arrest, that's when you should be entitled to a free lawyer. Is that phase where it's like you don't pay in time. That could be, I don't know how long down the road is that. So this can be seen as unfair. It criminalizes the inability to pay and affect those with lower income. There's something about notice requirements for out-of-state visitors or non-residents. So it's worded like the notice must be reasonably calculated to inform. So they put the state will say they'll calculate where they think your last address was, and that's their calculation, and then it's considered reasonable that they attempted to contact you. So if you leave and then come back and you have a warrant, and you may not know about it because the state relies on being reasonably calculated in their attempt. The combination of criminal and civil penalties, let's see, it allows for forfeiture actions to be combined with criminal charges. So it'll subject you to multiple penalties for the same offense. And that's happened to me multiple times. I got jailed twice for the same offense. And this is something that's not just forfeiture. The court can take it to the next level, to a criminal level, but they're avoiding the criminal aspect and the jailing aspect in the initial phase of this process. So it's really quite a tricky, a nice trick that they're playing in the law. Discretion in forfeiture amounts. So the courts are allowed to determine the sum in relevance to the proportion of the offense. So there can be inconsistencies in the amount of forfeiture between defendants, between judges. The judges determine how much. So you want to see a little consistency there, which may not be the case. Liability of municipal judges. Section 778.18 holds municipal judges liable if they dismiss or reduce forfeitures without proper authorization. This could put undue pressure on judges and potentially affect their impartiality. So they just can't drop the case. It's all on the prosecutor, and the judges are kind of pushed in the direction of getting convictions under this law, because if they don't get a conviction, if they just drop it, they could be subject to having to report their license or report their bond agency or their insurance, something like that. No opportunity for delay in payment. Judges cannot give time or delay for payment which might be necessary for some defendants to arrange finances. Okay, so they want to pay immediately so that they can reach that point where if you don't pay in time, they can start criminal actions against you. Broad definition and scope. The definition is broad and includes penalties in money or goods. There was something mentioned about blood in the law. Maybe I can go up to that. Let's see. I'm gonna make an attempt to just look. There's something mentioned about blood. I know I did not. Yeah, I can't just search for it either, huh? Civil. Yeah, I don't know if I'll. Blood, okay. A prosecutor may engage in negotiations relating to a defendant's reimbursement of blood withdrawal and expenses, but a prosecutor may not, as a result of a defendant's payment or offer of payment of blood withdrawal expenses, dismiss or amend the charge, citation, or complaint, or forego the initiation of a criminal prosecution action or special proceeding based on the violation. So what are they talking about with blood? A blood withdrawal expense. So it sounds like they're really cutting into your your life, your network, your life, the soul of your life. Okay, so that's forfeiture. Forfeiture is not exactly fair. This forfeiture law in Wisconsin, and then you got the different. Then I'm trying to figure out because there's none of that in the forfeiture talks about discovery of evidence. That's in either 804, which is civil, or 971, which is criminal. These are the statutes. So I asked, what's the difference between civil and criminal codes of procedure for discovery evidence? And then ChatGPT defines the civil, which allows you to discovery in civil cases can include depositions, written interrogatories, requests for production of documents, physical and mental examinations, and requests for admissions. So there's interrogatories, there's depositions. If we're doing civil, then I'm allowed to depose the cops. But if we're doing criminal, then there's more protections for the witnesses, and it doesn't look like I'm allowed to depose the cops. So that's what I want to get straightened out here. I want to tell the judge that I intend to depose the police officers, and depending on whether they allow or deny that, I'll know which direction we're going for civil or criminal with forfeiture law, because forfeiture law just swings between civil and criminal depending on the judge. Forfeiture law does not specify that it's criminal or civil. So, I mean, from what I read at least, and it's all in, let's see, is there any law involved in defending, okay, it's all in 778. And I mean, that's a lot. There's a lot going on in Wisconsin statutes, but they all don't apply to me. I just want to focus on what's relevant. So yeah, there's a lot of things, and I'm just trying to narrow down. I'm deleting stuff out of the law that doesn't have anything to do with me. I could accidentally delete something that may have something to do with me, but that's the risk I take. I just want to focus on what looks important. So there's what I'm learning so far with Wisconsin is that there's differences between civil and criminal for discovery, and that's going to be influenced by forfeiture law. So I can't specifically say with forfeiture law I'm in civil or criminal until I talk to the judge, and then I'll just start maybe start with criminal. I already made a motion referring to criminal, and then if the judge says it doesn't apply, I can pivot and switch over to the discovery on the civil code of procedure instead. That's my strategy right now.